The state has rested its case in chief, and I understand that the defense has a motion that would like to be heard at this time.
Your Honor?
Yes, sir.
Have we identified all the exhibits that have been identified but not admitted, Your Honor?
We have, and me and Dana's lists are consistent with each other.
Okay.
If anybody wants to look at the list, y'all welcome to do so.
Thank you, Your Honor. May I proceed, Your Honor?
You may.
As to the motion for directed verdict, the state defendant on behalf, counsel for the defendant moves for directed verdict and for the court to discharge him, and in support of would provide the following. First of all, Your Honor, the state was charged with crime of capital murder, kidnapping. As the court knows, kidnapping has two basic components. Either there's some type of asportation that someone is taken and they move without their will, or the second part is whether or not someone is inveigled, and that is basically under case law, and I think in the statute, a luring, trickery, or a threat, proof along those lines. So it's clear that the state has not placed in the record any proof whatsoever for the jury to consider that Mr. Lee was held against his will and transported, or there's no proof of asportation of Mr. Lee to any other location. So that puts us down to the embezzlement. There's no evidence whatsoever there was any trick associated, or they haven't advanced any proof that there was any trick associated with any conduct on part of Mr. Harrington, whereby he was tricked into coming to a location where Mr. Harrington was and kidnapped and held against his will at that time. Second, Your Honor, as to the threat, it's clear in the record that all the witnesses for the state, investigative witnesses, Chief, as well as Baker and Fortner, none of those three witnesses advanced any proof whatsoever that he was threatened in any way, or there was a threat placed against Mr. Lee that something was going to happen to somebody else if he failed to come to the location where Mr. Lee was. Now we're down to the last aspect of embezzlement, which is the luring aspect, Your Honor. Basically what we've heard in the courtroom today is a summary or an interpretation of one statement, subject to multiple interpretations, as testified to by Detective Baker. In his own testimony, Your Honor, he stated it's open for anybody's interpretation as to exactly what they were talking about. That's what Detective Baker testified to. The Chief testified that basically one word in the statement pertaining to what was going to occur before he was going to go back to block is the evidence of embezzlement, that there was a luring based on that particular statement. Your Honor, the evidence does not support that beyond a reasonable doubt that a jury could find that there was any luring by my client if you take the state's testimony most favorable to the state and give them the benefit of any and all evidence most favorable to the state. Additional argument as to the motion for directed verdict, Your Honor, pertains to the quality of the evidence that was placed into the record. The notice was filed on 11/5/24 pertaining to the 902.11c objections. The notice was filed, the objections were filed on 11/19/24. Your Honor, within that time frame, the court knows certain things were supposed to happen. The state at that time was required by law and required by the rule and the case law that they were supposed to set this matter for hearing, and the court was to rule on whether or not the objections were valid and whether or not the evidence that was in the notice would be admitted into evidence. The only piece of evidence that the state should be able to advance as to the 902.11c would have been one video. If the court had granted the state's objections based on the rule of court. And I'll state exactly how it goes, Your Honor. An adverse party waives any objection that is not specifically stated in writing, which we did, served within 15 days after receiving the notice required under paragraph B, or at a later time that the parties agreed on. That did not occur. The proponent must schedule a hearing on any objections, and the court should determine the admissibility of the record before the trial or hearing at which it may be offered. If the court cannot do so, the record is not self-authenticating under this particular paragraph. The court made a ruling, Your Honor, that basically two things occurred. The court made a determination that there was sufficient indicia of reliability for these particular documents, Your Honor. That is not in the rule. That is not the mechanism by which the rule authorizes the introduction of these particular documents. The court also made a determination on the record that the court was familiar with the locations within Wlbt County, and that due to that, part of the ruling included, due to the fact the court was familiar with those particular locations, certain pieces of evidence that included the videos of Jay Lee's car traveling throughout Wlbt County in different places and showing Jay Lee leaving his apartment, things of that nature were allowed into evidence. Your Honor, the defendant respectfully submits to the court that that was error, and those matters should have been excluded. And at the conclusion now where we are of the state's evidence, that there's not sufficient evidence, value of the evidence is not sufficient for this case to go forward on murder, capital murder, or any other charge, Your Honor. Now, getting to the last argument. The defendant filed a motion to dismiss this case on a defective indictment. Document 98. 12/2 of this year in chambers before voir dire. A hearing was had wherein the court, without advancement by the state, ordered that the indictment be amended. To this date, Your Honor, that indictment has not been amended by any order, not on the file, and the state's rested. There's no order amending this indictment, although unprompted by motion, there was an order that the indictment should be amended. Unfortunately for the state, they've rested without an order being on file amending the indictment. We move forward on a defective indictment. The state has closed their evidence, and directed verdict should be advanced. Our motion for directed verdict should be granted based on the procedure that's taking place in this file, Your Honor. I checked a few moments ago. I had Mr. Dagnall check. No order's been entered amending the indictment, and therefore, that part, in addition to all the other portions of the motion for directed verdict, taken as a whole, quality and quantity of the evidence that presented here today, the fact that the order amending the indictment has not been placed in the court file signed by the court, in addition to the fact that the state has failed to make a prima facie showing that a jury should consider the luring aspect of the embezzlement. And additionally, Your Honor, if you recall the testimony of Chief McCutcheon, he said that there was a time frame of 6 o'clock to 7:28, the time frame by which he anticipated that Mr. J. Lee, between that time, died. There's absolutely no proof of a death. The element of luring is insufficient as presented to the jury. The 902.11d requirements were not followed, and the introduction of those tapes should be stricken at this time, removed from the record, and furthermore, Your Honor, no amendment to the indictment has been placed in the file. Hence, we went forth on a defective indictment, and this matter should be dismissed by motion, granting the motion for directed verdict.
All right, anything else?
That's all.
I'll hear from the state.
Mayor, I will start in reference to the indictment. I sent the amended indictment to the email address bhartfield at forestcounty.ms.us shortly before voir dire as directed to by the court. It was emailed at 9:55 a.m. Apologize. I sent the, when we were in Hattiesburg, Your Honor stated that we needed to get the indictment on file before we started voir dire. I sent an email to the email address bhartfield at co.forestcounty. I believe that's Brooks' email. Is that your email? B. Hartfield.
Deputy Clerk of Forest to print it out.
Oh, I was instructed to send it. You told me to email it to B. Hartfield, and that's what I did. I emailed it to B. Hartfield, as well as CCing Mr. Creekmore and Mr. Haran. So while there, that's what I did, as instructed. I did assume that it was printed out. I wasn't sure whose email that was, but I was told to send to bhartfield at forestcounty.com. So that's what I did. So I'll address that first. The amendment was completed and it was sent at on 12/2/2024 at 9:55 a.m. Before we started to select the jury. Now, I assumed it was printed out and given to the court and all of that, as that was what was told to me to do. As to the argument to the actual elements of the crime, as the court is aware, the standard for directed verdict is to take the evidence in the light most favorable to the state. There's been ample testimony that this all happened on July 8th, 2022. Jurisdiction has been testified to by, I believe, Shane Fortner, and a witness today, I believe, Chief McCutcheon. He also testified to it. As to the element of death, we of course had to prove that Jay Lee was a human being and that he was no longer alive. The court heard testimony from Jay Lee's mother, who testified that he called her every day, they spoke every day. His friends, two at least, Khalid Fears and Jose Reyes, who testified that they hadn't seen or heard from him since that day in July, or for Jose, since July 7th, 2024, that he hadn't appeared on social media, that he regularly engaged in social media, possibly posted on social media every single day. We've heard testimony that his dog, whom he was very close to, was abandoned, that he would take photo shoots with his dog, that he would take the dog everywhere with him, even to class. He wanted to take it to class, that the dog was abandoned. We heard testimony from officers regarding his financial accounts and his mother, that to this day those accounts remain untouched, that the last transactions that happened on those accounts was July 8th or July 7th, 2022, besides some accounts that had automatic charges that could happen without him. We heard testimony that there was no evidence that he had suicidal tendencies, that he was depressed, that he was unlike him to disappear on his own. Further, his ID, all his credit cards, his driver's license, things that he would need to be out into the world were all found within his vehicle on Molly Bar Trails, which was parked there at 7/8, the same day he disappeared, and towed the same day he disappeared. We heard evidence that his apartment remained unpacked. All his possessions were still there. Nothing was taken or removed. Your Honor, we provided sufficient evidence to where a reasonable juror could determine that Jay Lee was no longer alive. Maybe I should forward it. As to the element of kidnapping, Your Honor, opposing counsel defined there's 3 types of kidnapping. That's what the case law says. The theory by which the state proceeded under was a theory of inveiglement. Now, inveiglement specifically means to lure or entice through deceit or insincerity. And there's no component of force, and you cannot forcibly inveigle, which is why the state was confused regarding all of the force talk. It is to essentially lure or convince someone to come to you by being insincere, through trickery, or through deceit. In this case, Your Honor, the text conversation between Jay Lee and Timothy Harrington is very important. It actually starts off where we know that Jay Lee has left Timothy Harrington's apartment upset. We know that based on Timothy Harrington's recorded interview, where he stated that Jay Lee was mad when he left. We know that because Jay Lee blocked Timothy Harrington after he left, and people don't usually block people that they want to continue to communicate with. We also know that Jay Lee said something that could be perceived as mean to him, talking about how I nutted on your floor back to block. Following that, Jay Lee is communicated on an account that he doesn't recognize. We know he doesn't recognize because he says, "Who the F is this?" Then Timothy Harrington re-engaged Jay Lee. His first message to him was, "Come back." But before he stated that, Your Honor, he calls him 3 times unanswered. Then there is one answered phone call through Snapchat for 14 seconds. Then the conversation then continues between the two. And at this point, we realize that Jay Lee knows that it's Timothy Harrington because they pick up their conversation back from when he was blocked. Your Honor, at this point, he asks, "Come back." Jay Lee says, "No." He says no. Tim Harrington continues to speak to him. Jay Lee responds with why he won't come back, again indicating that he wasn't going to come over. And it's important what he said because it wasn't just that Tim Harrington wouldn't perform oral sex on Jay Lee. In that message, Jay Lee describes having been treated poorly by Tim Harrington. He says not only that he didn't reciprocate, but also he insulted Jay Lee by telling him to stop harassing him and telling him that they would stop linking, as in meeting up for sex. And this was immediately following their sexual encounter. That's why Jay Lee was upset, and it's laid out in that message. And then, Your Honor, he tells him he's gone too far. Jay Lee says to Tim, "You've gone too far," and says good night. Again, Tim Harrington says that he doesn't want it to end like this. He tells Jay Lee he's a cool person. Jay Lee then says that his one condition to come back was if Tim would agree to give him oral sex. Now, per Tim's own interview, Tim Harrington's own statements, he invited Jay Lee back over to make it up to him. That's Tim Harrington's statements. Tim Harrington says Jay Lee was mad. Tim Harrington says he had to invite him back over and promise to make up to him. But what's really interesting, Your Honor, and what goes to the deceit, trickery, or luring is that Tim Harrington also says in his interview that he never does that. He never performs oral sex on men. He says that he's never done it before. He says that Jay Lee usually comes over, but this time he's promising to do something he's never done before, which is what he says in his interview. That also came from Khalid Fears, that Jay Lee was going to do something sexually that had never happened to him before. Tim Harrington in his interview, after saying that he's going to do something he's never done before, when you think about that, Your Honor, the evidence and context of what's happened, Jay Lee had just left this man's apartment. This man had just told him, stop texting me, had just told him, I don't want to see you anymore. Then, after Jay Lee says, I just wanted to be able to say, I had you BDL, and blocks him, suddenly, Tim Harrington is calling him over and over again, texting him over and over again, asking him to come over to do something that Tim Harrington didn't want to do because he never did it before. Further, as proof that he never wanted to do it, Your Honor, Jay Lee brings up, well, I'll come, but, I'm gonna have to get this in the front. And Tim Harrington, he just says, in the text message. Then Jay Lee doesn't even know what that means. He says, okay, I'll do it. Because he never intended for Jay Lee to come over there for oral sex. The evidence could be perceived that way, Your Honor, and that's how the state reads it. It's very obvious. He never intended him to come over for sex. And then further evidence by that, and that he wasn't enthusiastic to do it, is that immediately following Jay Lee's agreement to come over, Tim Harrington Google searches, how long does it take to strangle someone? Your Honor, even Jay Lee in the text was confused by Tim's repeated calling and texting and asking him to come over because he says, why are you doing this? It's like you're trying to lure me, because that was not the tenor of their relationship, and that's very clear from the text message. And a jury that heard that could reasonably infer that. Your Honor, Tim Harrington, when you look at the evidence in whole, the conversation in totality, in combination with his interview, it's very clear that Tim Harrington didn't care about Jay Lee. When he asked him to come over, it wasn't because he wanted to be on good terms by doing something he never wanted to do in the first place. That was the insincerity, and that was the trick, that was the deceit. As we further move on in considering the theory of inveiglement, Your Honor, I would cite to the Moberg case, 303 Southern 3rd 815. I believe opposing counsel said as to kidnapping, he had to have the intent to keep him or snatch him. No, Your Honor, if the court looks to Moberg, in that case, they talk about how kidnapping is not a specific intent crime. The significance of the...
There's an inveigling case decided a couple of years ago. Was that it?
No, this is actually newer, Your Honor. I believe this is from 2024.
2024. I knew there one very recently. That's probably it anyway.
Your Honor, they say the significance of the holding that no specific intent is needed is that the defendant need only to have the intent to cause the events that followed. In that case, all that happened was the defendant, Moberg, was upset that the victim had slept with his girlfriend. He told the victim, we're cool. Then he went over to the victim's house and he asked him to come help him with stuff. He asked him if he would help him move. Then the victim and the defendant drove from, I think it was Alabama, to Mississippi because the victim voluntarily agreed to help him move. The victim was then killed in in Mississippi. Eventually, his body was found, although no cause of death could be determined. Moberg appealed and said that there was no evidence of kidnapping. But as here, the victim voluntarily got into the defendant's truck under the guise that he was going to help the defendant move. Jay Lee did voluntarily go to Timothy Harrington's apartment, but of course it was under the guise that Tim Harrington was going to perform oral sex on him. But again, Your Honor, the evidence put forth is that, one, Tim Harrington has never done that before. Two, he didn't want to do it earlier in the night, so much so that he told Jay Lee, let's stop linking and stop harassing me. And three, that Tim Harrington only suddenly became interested in having Jay Lee come back over after Jay Lee blocked him and made the statement, I just wanted to be able to say, I had you BDL. And I would further state, Your Honor, that per the evidence provided, a reasonable juror could reach the conclusion that Tim Harrington, following Jay Lee coming over to his apartment, and that 7:28 time was important because that's when Jay Lee's phone completely cuts off, never comes back, that Tim Harrington is then seen taking this fantastical run that he describes in his interview, somehow getting into Molly Bar Trails without ever running into it, right after Jay Lee's car is parked at Molly Bar Trails. So I put forth, Your Honor, that the state has, in fact, put forth a prima facie case of death, kidnapping, and altogether capital murder. As to the indictment, Your Honor, I did what was directed to me.
The issues on the South authentication issues, or let the court handle them on his own?
Well, Your Honor, the court already ruled. I believe that ruling, I don't believe that that was the proper place for, or the proper subject of a directed verdict argument. The court has ruled there was sufficient indicia of reliability for those documents. It is not true that the only one tape would have come in. The campus walk videos, Your Honor, are from UPD testified to those. The campus walk, the campus videos, that's from the university. University police is in charge of the university. Those came in through the university. To the Renaissance Bank videos, the Renaissance Bank woman was here. The videos from the cleaner woman was here for that. Mr. Klink was here for the videos from his home. We called the witnesses. The other videos, Your Honor, was the Walmart video. The Walmart representative was here. So, Your Honor, that's not true that only one of these videos would have come in. The witnesses were here to authenticate them.
All right, I'll give you rebuttal.
Yeah, Your Honor, first of all, the case that she cited involving the inveiglement, there was clear evidence, as I understand the case she cited, Mr. Dagnall and I discussing, there was evidence of the exact purpose of the representation about the purpose of the trip, getting that individual over there, which was false. There's nothing in this particular case, Your Honor. Mr. Fierce testified that the man was going over there to have some fun. There's no misrepresentation to Mr. Lee as to what the intent was when they were coming over there. There's one, according to their state's witnesses, Your Honor, there's one and only one witness testified, that chief, who wasn't involved in the investigation, basically made reference to, I just wanted to be able to say, I had you be the DL again. Subject to multiple interpretations. How in the world are we going to move forward on an inveiglement case when the state has presented their proof that that is the evidence of inveiglement, Your Honor, during the course of the conversations between these two individuals? I can't imagine moving forward with that scant amount of evidence, going forward with a capital murder case where Chief McCutcheon said that he couldn't present any evidence previous to the 8th day that they'd had any conversations that supported that my client had lured him over there, that had any other arguments or anything like that, Your Honor.
All right.
The second thing on the 902, the only tape that would have come in would have been the body cam. The argument is that the procedure that was followed, Your Honor, was an improper procedure, and that evidence, I know the court's ruled on it, should...
On those down at Grenada, I think that, I don't think the rule doesn't require that there not be self-authentic, that you can't put them in, it just means you have to bring authentication, right?
No, Clint could testify, Your Honor, but what evidence at the time without the other videos show any crime? What evidence without the other videos and the Oxford videos showing a boxcar going down the road supports a conviction? If the court went back in chambers and said, you know what, I probably didn't do it right on that 902.
I'm not.
I know you're not.
No.
But my point being, and I no disrespect to the court, but there's nothing in that rule that talks about indicia of reliability. It's not in there, Your Honor.
All right, I'm ready. Unless you got anything else? I don't mean to cut you
Can't
off.
think of anything else.
All right.
But
All right, I'm going to make, I'm this time.
now, hold on, Judge. One more thing about this order on this indictment.
Okay.
I hope we're not going down that path today on the capital murder case that you can email an order, amend an indictment somewhere, and stay here 9 days and not get it filed and signed by the court before the close of the state's case. Or even the start of the case, to be honest with you. I hope we're not going down that path, Your Honor.
Right.
Thank you.
Here we go. As to the self-authentication matters of videos, the court thinks it got it right. And I think we've made a record on this before, but I'll go back and sort of recap that. The state filed its notice of self-authentication. The defense filed a response, and our court finds it was in a required time. You filed it within the required time. The state indicated that they did not get that notice, that the defense was objecting until it was brought to their attention on Monday, was 2 weeks ago when we was having court in Ripley. We talked about this in chambers. That was Monday before Thanksgiving. Court said we'll deal with it when we can have time. The court took it as we were having a hearing on it. As to those videos that the court was found were all here in Oxford, Mississippi, on a short route, all in close proximity in time, all in a route known to the court. Court found that those I was going to, if I had a formal hearing on the record, I would have allowed those documents to be self-authenticating. Time didn't permit it. From the time the state, a formal hearing, from the time the state found out that there had been an objection to the current time. If the court is wrong on that, I think there's still sufficient evidence in other means of this court that phone records, Snapchat records, records from Walmart, that there was self-authenticating, that there was authentication made, police department, university cameras and things like that, that the case could have survived a motion to direct a verdict, even if the court was to be deemed wrong about that. As to the sufficiency of the evidence, I think the state has set forth a prima facie case that that Mr. Harrington was alive, that he is no longer alive. There's a prima facie case that he came to his death at the hands of Mr. Harrington. The jury could see it that way. The good jury could see it another way. They made a prima facie case. They've also made a prima facie case that occurred in Lafayette County on July the 8th, and they've made a prima facie case based on the text messages, as I call them, communications between these two parties, that there could have been luring in this case. Don't know that that'll be for the jury to decide, but they've made a prima facie case. As to the issue of amendment of the indictment, the court on the record ordered that the indictment be amended, that it court found that the statute required the code section of the underlying crime in a capital murder case be included in the indictment. The court further found that there's only one code section for kidnapping in the indictment, that there's no surprise to the defense. There could no way it could change or affect the defense in this matter, with the fact that those few numbers for the kidnapping section, code section, be included in the indictment. Kidnapping is kidnapping is kidnapping in Mississippi. There's no different statutes for kidnapping. The court allowed the indictment to be amended to include the code section number for the kidnapping. I direct and I ordered that the indictment be amended. This court has no knowledge other than what's been reported to the court this morning, that it was emailed. We were in Hattiesburg, picking a jury for this case. The state indicated when and where they emailed it to, and I'm going to deny your motion for directed verdict in this case. You can make any further record you like.
Your Honor, I think I need to clear up that the order failing to amend the indictment, the motion for directed verdict would be that the court should grant it. Alternatively, would be that due to the fact that the indictment wasn't amended, that it would move forward to the jury on, since the kidnapping aspect would not be viable, it would go to the jury on murder, as opposed to if the court found the prima facie showing had been made.
I'll ask for the state to make a response to that. They may be willing to confess that anyway. I don't know. The court is not going to, if the state wishes to move forward without the kidnapping, I'll allow them to, but if they don't, I'm going to play the cards we got, okay? That I'm going to. All right? Let the parties both know what you've uncovered there anyway. Apparently the I'm not going to make any comment on that on the record. If anybody else wants to, they can, okay?
Your Honor, based on what, been provided, my understanding what was sent is not anything close to an order amending the indictment and not signed.
I will say for the record, I have not signed an order amending the indictment. I have made a pronouncement from the bench that, so the record's clear, I have not signed an order amending the indictment. I have pronounced from the bench that the indictment would be amended. For the record, that's where we stand anyway. Okay.
I understand.
All right. It's 12:30. We got another hour, and we will, unless there's something else, will the state, you think the defense be ready to move forward? I would like to cover this right now in case I forget it later. Mr. Harrington, I'm going to direct this line of thoughts to you personally, not necessarily to your attorneys. The state has rested its case. You have the right to put forth testimony in your defense. You have the right not to. You have the right to testify in your own defense, or you have the right not to. If you choose to testify, you'll be subject to cross-examination by the state. If you choose not to testify, the jury will be instructed that the fact that you did not testify could not be used as any evidence of that you were guilty of any crimes. The decision whether you wish to testify or not to testify is your decision. It's not the decision of your attorney. I encourage you to consult with them. They've been in this game a long time and know what they're doing. But ultimately, the decision to testify or not to testify will be your decision. I'm not going to ask you what that decision is at this time, but at some point before the trial is over, assuming you're putting forth other witnesses, which I understand you are, but even then, when you've called any other witnesses, I want you to be prepared to tell the court whether you wish to testify or not to testify, okay? All right?
Thank you.
All right. Court's going to be in recess until 1:30. If y'all think of anything else we need to cover before then, I'll be around so that we can do that, so the jury be ready to go at 1:30.